Good morning to all of you. Video number 1462. This video is for the law of tort students. Previously, we discussed the vicarious liability of the master and servant. The most important point is the liability, vicarious liability between the state and its employees. So, if any act of tort is done during the course of employment, if he is a government employee and when he is performing the duty, that is sovereign duty, discharge of official function, then the state will come to his rescue. That means the state will pay compensation. But please remember, should be on duty and should not exceed his job position. So two cases are more important here. That is number one, state of Rajasthan versus Vidyawati. Very good case. State of Rajasthan versus Vidyawati. Definitely you will get a question on this. There is no doubt. Please remember. So what happened is in state of Rajasthan versus Vidyawati 1962 case, husband of Vidyawati is Mr. Lokumal. What happened is the collector of Udaipur's jeep was under repairs with a shed. So that man got the work done, repair works were done. Ultimately, he was coming back after repairs, he was coming back to the collector's bungalow. En route, the petitioner's husband was knocked down by the speeding jeep. Actually, Vidyawati's husband was walking along the footpath, but he was knocked down. No doubt, whatever it is, there may be so many reasons for the called accident. So accident is one which is not expected. Is it not? Right? You do agree? Okay. Now, so after this, actually the husband of Vidyawati, he died after some days. And she filed a case. She brought a suit of tort for compensation. In the initial stage, state of Rajasthan did not agree, but the lower court said that no doubt the driver may be a probationer, but it is his duty to run the vehicle in a safe manner, not overspeed. Ultimately, since he is negligent, that too, since it is not the official discharge of duty. When the collector sits in the jeep, definitely it becomes a sovereign function or discharge of duty. When collector is not there, so it cannot come under the so-called sovereign duty. Therefore, you have to pay. So this is the judgment. Ultimately, state of Rajasthan went in appeal also. So they have quoted, actually Rajasthan government quoted Article 133 of the Constitution of India. Ultimately, it is not allowed. And the Supreme Court held that according to Article 300 of the Constitution of India, definitely the state is bound liable for the act done by the employee in discharge of his official duty. He is on duty, therefore he is liable to pay compensation. This is a very good case, particularly state of Rajasthan versus Vidyawati. So don't forget this case, and I am sure you will get a question on this. So jocularly I will be telling friends, if you know three Vatis, so this is Vidyawati case. Second is state of Rajasthan versus Premvati, or Premvati versus state of Rajasthan. This is another case. So this happened in the year 1977. So in this case, the driver of the vehicle took the jeep from the workshop, and thereafter, instead of taking the jeep to the garage or to the concerned department officials, that is garage, he has gone for a joyride. Joyride means happy ride. He has gone for joyride. Actually, is after repair. Same thing. State of Rajasthan versus Vidyawati case laga ikkada kuda repair jarigintadu manodu saradaga trial kosamo deni kosamo he went for a joyride, and that too he was going on a spree. సరదాగా వెళ్ళిపోతాం, చాలా ఫాస్ట్గా వెళ్తున్నాడు. వెళ్ళేవాడు పోకుండా en route he has given pickup or joyride to some third parties. So so due to the joyride, there was an accident resulting in serious injuries to all the passengers. Who are they? They are all unauthorized passengers. The government did not expect him or did not entertain him, did not ask him to give lift to all each Tom, Dick and Harry. So definitely in this connection, an action was brought against the state government because out of the three, two persons died, I believe. So actually this action was filed or tort was filed against the state government, making it vicariously liable for the negligence. So here the court did not agree. Although bringing the jeep from the shed to the bungalow or to the garage is an official duty, but the government could not be made liable, number one, because of the trespass by the unauthorized passengers. So they are not authorized passengers, no doubt. They may be gullible public, they might have, they may be his friends. So this cannot be accepted. The government was not liable to them. Why? Because they were unauthorized passengers, and that too, it is not his duty to give a lift to each and every person. So, unauthorized person is to be outside of the purview of the job of or the course of the employment, you can say that. So these two cases are most important, please remember. So we'll discuss some more cases later. Thank you very much.